Fast Food Council meeting for the very first time today in Oakland.
Yeah, the group will bargain wages and working conditions for the state's 500,000 fast food workers. The council is made up of a blend of labor and fast food industry leaders. The group decided today to post a job for an executive director to help manage the day-to-day operations of the council. The minimum wage for fast food workers goes up to $20 an hour in April, but the leader of the council says there's much more work to do.
I think one of the good things that happened today was that I think what you heard from each member of the council is that they're here to work. We have a kind of a unique representation. You have workers who work in one of the lowest wage industries in California, and then you also have representations of franchisee owners who represent small businesses. And if there's any two people that are struggling right now in the economy, I would say it's small business owners and it's workers. So I think what I was happy to hear was both sides being, both representatives from both the worker side and the employer side saying they're ready to get to work and work together.
Now, meantime, the law that created this council is at the center of scrutiny right now. As we've been reporting for the last couple of weeks, non-disclosure agreements were used in the final negotiations of the law. The labor group, Service Employees International Union, also known as SEIU, required them.
And after days of not commenting on that, the group finally broke its silence on the issue today. Their spokesperson, Mike Roth, releasing a statement. And we're going to read that to you now. The statement reads, quote, "This story is a nothing burger made of innuendo and hype. KCRA's reporting repeatedly, intentionally, and inappropriately fails to distinguish between conversations taking place between private parties and the public process by which a bill becomes a law. California's landmark law lifting 500,000 fast food workers out of poverty and strengthening their voice at work went through a full, transparent, again their words, and public process required by law." The statement goes on to say that the suggestion that private parties cannot or should not have confidential discussions to resolve their differences is absurd. End quote. Our Ashley Zavala has been covering the Fast Food Council meeting that happened today in Oakland, and one of the members of the council is SEIU International Executive Vice President Joseph Bryant.
Now, Ashley was able to talk to Bryant and ask about that statement that we just read in our ongoing reporting on the use of NDAs during legislative negotiations. Here is part of that conversation.
Do you think our reporting is a nothing burger? Do you think our reporting is hype and innuendo?
Joseph, I don't think you've read that report in particular, and that statement wasn't from Joseph.
I have not read that report.
Okay. The use of non-disclosure agreements. I mean, did you know that those were used?
We were at a place where we met impasse in the legislative process, and we were asked by leaders at the state to say, "Hey, figure this out." And in these spaces, again, when you have entities that come from very different interests, ours, coming from the perspective of establishing, a voice for workers at the table, businesses coming from their perspective, in order to, have conversations, sometimes it does take, steps to be able to establish trust.
The legislation was put into print on September 11th. It passed September 14th, which was the final day of the legislative session when state lawmakers are sorting through hundreds of bills. I mean, is a 3-day fast-tracked process of good representation of the legislative process?
I would say this has been an extremely long process, that was the last phase of the bill. Obviously, the bill went through many open hearings, many committee meetings. It was debate on the floor, both at the Assembly and the Senate. And there was a lot of community engagement. There was engagement from the industry. So, from where we started to get to the place to where we're at of September 14th, it really was a process of multiple years.
Were you a signee of an NDA in this?
I would prefer not to comment.
Okay, could you tell us at least the terms of the NDA, what they covered, how long they were were set to be applied to any of this? Did they expire?
I would say the one thing, again, I feel like it takes away from what we were able to accomplish.
It's your organization's opinion that these were private conversations, but this is a law that impacts the entire state. The mediators of this were paid for on the taxpayer dime. The systems in which this law was negotiated were also paid on the taxpayer dime. Why should NDAs be used in that process?
And I think what happened absolutely benefits the state of California. You're talking about we are dealing with a crisis in regards to homelessness in the state. 6% of the the homeless population are fast food workers. So this is something in terms of increasing the income of fast food workers helps all Californians. We have a exorbitant number of fast food workers who rely on assistance programs. We have exorbitant amount of fast food workers that have insecurity in regards to the state, whether it be housing, whether it be able to take care of their families. And what this piece of legislation did was help California by helping Californians who are fast food workers, and to be able to also lift up everyone in the state.
Okay, the bottom line is we have not been able to find any public records spelling out how and why certain exemptions were added to that bill. And legal experts and legislators we've spoken with tell us they have not heard of or seen NDAs being used in the legislative process, and they do not think it is appropriate.
Governor Newsom's office has said none of its staff signed the NDAs. It has not said if it was aware that they were being used and if it approves of their use in the policy making process. We'll continue to follow this story as it unfolds.